I got a great question that we're going to focus on next because we have a lot of small businesses in Southwest Florida. And one of the big considerations we're thinking about when a person who's a sole practitioner or they have a corporation or an LLC, we really have to focus on accounts receivable or executory contracts. These are things that are in the process when a person files bankruptcy. The easiest way to look at it is, let's say, for example, you work on commissions. Let's say you're a realtor. At the time you file bankruptcy, meaning Chapter 7 or Chapter 13, any executory contracts, you got a sale coming up, you file bankruptcy today, September 8th, 2011, and you've got 2 closings next week, meaning that you have the right to earn money on the day you file. The commission's there. When the deal closes, you're going to get paid. Unfortunately, if you file Chapter 7 bankruptcy, that money is going to go right to the bankruptcy trustee. That's a problem. So when you're one of the big problems with small businesses when they come to see me is usually they have a cash flow problem. So let's say you have accounts receivable out there. Accounts receivable are an asset that has to be listed. So if you're a sole proprietor and you've got $50,000 of accounts receivable, let's say you're a handyman and somebody owes you $50,000 for work you've been doing. Okay, great. If you were to file bankruptcy, that account receivable would go right to your bankruptcy trustee unless you could exempt some portion of it. But in Florida, the maximum you could exempt on that is $5,000, assuming you had no close or anything else. Let's just say $4,000. So you're going to lose $46,000 of that money because it's an asset of the estate. Same thing if a corporation were to file, or a sole proprietor. An LLC. What is your interest in the LLC? That's a huge question, because if the LLC is liquid, well, now we have a new LLC law, so I don't really want to talk about that until it's tested. But usually when you have a sole proprietorship or a small business, or even if you're just a 1099 employee, that's a problem. So it's something you definitely want to look at. An executory contract is something else. An executory contract is a contract that is in existence at the time. In other words, it hasn't been completed yet. You're working on it. You're working towards something. Or it's in existence and it's something that you're going to be doing in 5 months. You've got a thing that you can't do yet, but you're going to do it, but the contract's in place now. That's a problem. Those contracts have to be listed. If you're going to get money in the future from that, it's an asset of the estate. And whether or not you can exempt it's another question for you and your attorney to sit down and talk about. So these things, they need to be listed, they need to be disclosed. Once they're disclosed, then the trustee can make a determination on whether it's something that they can do. I've heard other attorneys talk about telling people to go on a forced vacation. In other words, just ride it out. Don't work. Don't go out and get new work. Go ahead and, excuse me, I'm sorry. Go ahead and take a little bit of vacation, a week or 2 weeks, get your receivables in, use them for living expenses, and then file bankruptcy. But then you got no work in the pipeline. To me, it's kind of 6 of one, half dozen of the other. I don't want my clients walking away from work on purpose so they don't have to pay their creditors. To me, that seems kind of underhanded. I would rather have my clients out there working, trying to get new work, trying to provide for their families. In other words, there's a thing when it becomes a fine line between gaming the system and being honest and forthright. I mean, if you've got the 2 closings, you disclose it. I had one realtor who's a friend of mine who had to file bankruptcy, him and his wife, wonderful people. They were they had made investments and they had a tough time with it. They filed bankruptcy, and I think he had a couple closings pending at the time he filed. But because he was such a busy guy, there was never going to be a good time for him to file. And he couldn't just walk away from his business. I mean, any realtor today out there, realtors are hard workers. They've got to keep churning the system. They've got to keep that wheel cranking. Otherwise, there'll be no money coming in. And, the argument was, do we have to go ahead and give up that money? And the answer is, yeah, you do. You have to give up that money. And it went to the bankruptcy court. The bankruptcy trustee took it, used that money to pay the creditors, as they're supposed to. But now we look back on it and, he said to me, Carmen, he goes, it seemed like a lot of money at the time. But the reality is once I got out, I got my fresh start and really put all that behind me, I could really focus on my business. In other words, I wasn't worried about creditors calling. I wasn't worried about this. I wasn't worried about that. Yeah, I wrote off that money, boom, it's gone, and now I focus on the future, and things have gotten so much better because I let myself put that behind me. Great. That's a perfect example of how to play the game right, how to, deal with it, and then move on. And a lot of people can't seem to get over that because I worked hard for that money. I get it. Everybody works hard for what they get. The question is, what is more important? Is it this commission I'm going to get today, or is it the rest of my life? And in that situation, I think the gentleman and his wife made a really good decision. So think about that.